Yes, today, yeah, taking off from where we left yesterday. So yesterday we discussed about what is inevitable accident. Okay, we saw that inevitable accident can happen, due to two different causes. Okay, two different situations. Okay, one could be due to elementary force of nature. Okay, also known as, what is the other name for that?
Act of God.
Yes, act of God. So yeah, something that's not due to human agency. Okay, the other one is maybe wholly or partly due to human agency. So this difference does not really exist as much, okay, as it used to earlier. I partially told you guys why. So, for example, the incident that I was describing to you guys yesterday. So, if the person whose car had been hit from behind were to take the other person to the court, okay, seeking damages, okay, so then that person, the plaintiff, has to say that it's a case of negligence, okay. So yes, so that means the burden would be on the person who's claiming that the other person has done the act in a rash and negligent manner, okay. That's what the plaintiff has to do. The plaintiff has to prove that the other person was negligent. It's not necessary for the other person to prove that it was a inevitable accident. That's not the case. Okay, so inevitable accident as a defense does not really exist the way it used to. But the other aspect, okay, that is the elementary force of nature or act of God, that used to be a defense in certain cases, as I told you, okay. For example, in case of strict liability, only act of God used to be relevant, okay, but not so much in today's time. So I told you that in MC Mehta versus Union of India, even act of God is not considered as relevant defense, okay. So it's not really that strong defense now. So why would that be? So one reason is this, that okay. So, think about this, okay, big companies come up with, okay, they have, big factories, big industries where they deal with hazardous, dangerous, material, okay. Now, they are doing their business to make profit, okay. Now, some accident happens, whether by, in a human agency, due to human agency or due to force majeure or act of God, okay. But the thing is that you are the one who brought the risk, in the first place. So, whether you foresaw, such a, act of God, in future or not, but the fact that you have brought about that danger and that danger has escaped and caused harm to others is considered sufficient ground for an action to be, possible. So that's the change that we see that as has happened. So we will discuss this in greater detail later on when we take up specific thoughts. So yes, I hope you guys understood, okay, all this, this specific, defense, okay, that is of inevitable accident. So let's look at some cases, okay. So the first case is by the name nitroglycerin case, okay, of 1872. I'll just write it there, okay. Yeah, I think I already have one question, okay. So yes, yes, inevitable accident. I'll just repeat it quickly once more because apparently it wasn't clear. So what does inevitable mean? Can you tell me what inevitable means? It means unavoidable.
Something which is bound to happen.
Yeah.
There is no avoiding that.
You could not have avoided it, okay? It's not because of your fault, okay? It was beyond your control, okay? You could not have foreseen this, okay? Just out of the ordinary, okay? So you know that, if there is a construction site, okay, it is possible that some debris fall from the, high up, okay? So you then cannot say that it was, it's a case of, you cannot say that you could not have foreseen it, okay? But when we talk about something that is inevitable, accident, that is something you could not have foreseen, okay? So any person of ordinary prudence, okay, will not be able to foresee that, okay? So as I told you, you could not have prevented an inevitable accident by ordinary care, caution, and skill. law is not expecting you to be super expert in that domain. So you don't have to be, for example, Valentino Rossi if you are a motorbiker. Law does not expect you to be that expert. Okay, so but any ordinary person. Okay, so you could not have averted it using your ordinary care, caution, or skill. Okay, we also said that okay, it is one out of ordinary course of things. Okay, something so unusual as not to be looked for by a person of ordinary prudence. So this is something, so you would never know that suddenly there will be, so for example, this place, for example, receives a certain amount of rain, and that has been the average which has been recorded over 200-300 years, but suddenly you see there was such a torrential rain that it caused maybe 2-3 meters of water at a particular place. Okay, that is something one could not have foreseen. So incidents of that sort, okay, is usually considered as a case of inevitable accident. And then there are two different kinds. Okay, one that is caused by human agency. So I told you that old fellow suddenly jumps in front of the car. Okay, that is due to a human agency, but you could not have foreseen that okay, in that fast lane suddenly someone would come before your car. And then the other one is force majeure, okay, or act of God. So and then there is a distinction between those two as well. I'll tell you guys later on. So that's inevitable accident. So let's look at some example. Okay, those examples will make it clear. So one is nitroglycerin case. Okay, I'm reading out from the book that I have. So the facts are like this, okay. So the defendants in this case, they were a farm of carriers, okay. They carry things from one place to another. They received a wooden case to be carried to its destination, and its contents were not communicated, okay. So what was there in that wooden container was not made known to the carriers. So on an intermediate station, it was found that those contents of the container were leaking. The case was therefore taken to defendant's office. Okay, the container was taken to defendant's office, which they had rented from the plaintiff. So the office was rented from the plaintiff. And a servant of the defendant, essentially the carrier, proceeded to open the case, okay, for examining what is in there, okay, what is it that's leaking. So the substance was nitroglycerin, okay. So it exploded, killed the people, okay, nearby, okay. All the persons who were present, okay, they were all killed. Even the building was damaged, obviously. So an action was brought by the landlord, okay, the plaintiff, the landlord, for damages suffered by parts of the building led to the tenants as well as to the defendants. So the part of the building was, led to the tenants as well as to the defendants. So what did the defendants say? The defendants admitted their liability for waste as to the premises occupied by them. They said that we should be held liable only for the premises which were held by us, okay, but disputed it as to the rest of the buildings, okay. So the rest of the building which were in others possession, they disputed with respect to that. It was held that in the first place, the defendants were not bound to know, in the absence of reasonable ground of suspicion, the contents of packages offered for carriage, and that without such knowledge, in fact, and without negligence, they were not liable for damage caused by the accident. So you see what had happened. So what did the judges find here? That the defendants were not liable, okay, for the others, okay, for the portion that they held, they were held to be liable, okay. Because the premise was wasted, okay, while it was in their possession, okay. But with respect to the rest, the defense of inevitable accident was allowed. So yes, that's essentially what. But as you know, had this judgment been, and had this case been today, okay, in today's time, okay, it's highly likely that the decision would have been otherwise, okay. Because back then, maybe this, because of what kind of standards were back then, so maybe the carrier was not expected to ensure what was the content. Okay, but as you know, in today's time, the carriers are expected to ensure what the content is. Okay, so for example, if you ship something, batteries or other inflammables are not allowed to be shipped, okay, couriered, etc., etc. So yes, the things have changed, but you know what the what inevitable accident here is. So the leak had happened. It was not done by, not because of the defendant's fault. Okay, they could not have known what was the content of the box. So how could they have avoided the accident? How could have? So because of that, the court did not impose liability upon the defendants. So is this case clear to you?
Sir, I had to ask something.
Yes, yes. Go ahead.
So the defendants were held liable for like their own premises.
Yeah, because see, that's for different reason altogether. See, if so, it could have been contractual as well. Okay, so why? So for example, if I rent out a premise, okay, to someone, okay, so there is a rent agreement between me and the person who's the tenant. Okay, if the property is in the tenant's possession, okay, the tenant has to ensure that the property is not wasted. Okay, so that's the duty that the tenant has, to maintain the premises without causing any waste. Okay, so the property has been wasted. Okay, I don't care what caused, whether it's because of your negligence or not. The fact that we have a contractual relation here, okay, that you keep the property in a certain way, you failed, so you have to. So that's a different thing, okay. That was not even disputed by the tenant. But with respect to the rest of the property, okay, that they were not in a contractual relation with, okay, with them. So with respect to that, they contested because it was a case of tortious liability, okay. So with respect to that, they said that, well, no, we could not have foreseen, this incident happening, so we are not liable. So yes, that was the situation. But as you know, these days, even all premises are, insured, and so some kind of, compensation are received from one source or the other. So is that fine?
Yes, sir. Thank you.
Okay. So the next case is by the name Brown versus Kendall. I'll send this quickly. Just a second. Brown versus Kendall. So in this case, what was the situation was that the plaintiff, and the defendant's dogs were fighting. Okay, so the defendant was, beating the dog to separate them. Okay, so while he was doing that, the plaintiff was looking on at the incident. Okay, so while the defendant was, trying to remove the dog as he was hitting, it hit the eye of the plaintiff and caused severe injury. Okay. So when the action was brought by the plaintiff, okay, it was held that the action of the defendant was a lawful and proper act in itself. Okay. Because he was just trying to separate the dogs. Okay. Which he might do by proper and safe means. Okay. So it was held that he was doing it through proper and safe means. And that if in doing this act, he accidentally hit the plaintiff in the eye and wounded him, it was the result of pure accident, and therefore no action would lie. So yeah, so it was held that the plaintiff was acting purely to separate the dog, and he had taken whatever care he could. So there was no negligence on his part. Okay, so because of that, it was held to be a case of inevitable accident. Now, if he was being extremely negligent, then the outcome of the case would have been different. Okay, so is it clear? Is it clear?
Yes, sir.
Okay.
Yes, sir.
We'll take two more cases. Okay, one is Holmes versus Mather. Okay, I'll type it here. So Holmes versus Mather is famously known as the runaway horse case. Okay, you will remember these cases, for as long as you are in law practice, because these are very famous cases. So what had happened in this particular case was that the defendant's horses, while they were being driven, okay, by the servant of the defendant on a public highway, they suddenly ran away because of some barking dog. Okay, so they became unmanageable, and the servant who was managing the horses could not stop them. Okay, so they started moving. Okay, so while so he was there, okay, he could not stop them, they were moving. So while he was safely trying to take a turn at a corner, he accidentally hit the plaintiff, who happened to be on the highway at that point of time. So it was held in this particular case that no action was maintainable, okay, as against the defendant, okay, by the plaintiff, for the servant, because he had done everything within his capacity, okay, in the light of the circumstances. And it was not his fault that the horse started running, because it got startled by the dogs barking. So yeah, it was held to be a case of inevitable accident. Okay, so is that clear? Very, very simple cases. You will remember these cases for a long time. Is that fine?
Yes, sir.
So one last case. Yes, tell me. Any doubt?
Excuse me, sir.
Yes, Vishwajit.
Sir, suppose we are moving by car in highway, and
yes,
suddenly car tire burst and accident took place. Can I get a defense under inevitable accident?
Yeah. See, now that depends. Okay, you have to prove that it was inevitable accident. Now, if the car was very poorly managed, if the tire was already in very bad condition, okay, it will be difficult for you to prove that it was, because you cannot just say that it's inevitable accident. Okay, you have to also prove that it was a case of inevitable accident. If it appears that the tire was very poorly maintained, that it was completely worn out, that you should have changed it, but you didn't, then the defense is not available. Now, for example, you only recently got a Bridgestone tire, I don't know what's good, or maybe a Polo tire, okay, and it was just a week back, or maybe a month back, or a year back, because you have warranties, etc. There was no such serious wear and tear, but suddenly it burst for whatever reason, okay, not known to you, okay, you could not have foreseen, then you can definitely avail inevitable accident as a defense, okay. But it was very poor, in very poor condition, that you had repaired it multiple times, and then obviously it will be difficult for you to prove that it was a case of inevitable accident rather than negligence. So is that fine?
Yes, sir.
So you have to prove from the circumstances, from the facts, you have to prove that, well, yeah, this is what the situation has been. So I hope this is clear. So we'll take one last case, Stanley versus Powell. So the defendant, okay, was at a shooting party, okay, and he fired a pellet, okay, at a pheasant, okay. One of the pellets of the gun, from his gun, it bounced off a bark of a tree, okay, and wounded the plaintiff. Now, who was the plaintiff? Plaintiff was the person who was put in charge of carrying the cartridges for the defendant, okay. So it was held in this particular case that the defendant was not liable. Why? The reason that was provided in this particular case was that it was a case of inevitable accident, okay. So this seemed to be okay. There was criticism for this particular decision. It seemed in the light of the facts that it was not a proper decision. It was not a case of the defendant could have been more careful, okay. Only if it had been more careful, then yeah, maybe this. But then there was another way in which the matter could have been defended, and that's another defense that we are going to discuss. The other defense would be volenti non-fit injuria, that you yourself have put yourself in the way of danger, okay. So that we will discuss, okay. So anyway, even in this particular case, inevitable accident was allowed as a defense for the defendant, okay. So is that clear so far? I hope this is clear.
Yes, sir. Yes.
Okay.
Yes, sir.
So let's take the next defense. Okay. So the next defense is no longer a defense. Okay. So parental authority. Okay. Parental authority. What does that mean? Okay. So it used to be the case, okay, that, parents had the authority to discipline their, kids, their child, okay. But what can they do to discipline them? Can they spank them? Can they hit them? Can a teacher, if you were in school, we grew up in a different time, we used to be hit by our teachers, so, insulted and all that. In school, okay, obviously in colleges we don't do that, nor is it justifiable, even to the children, okay. Even parents cannot, beat their children, okay. So, and teachers definitely cannot, okay. So under the Right to Education Act, it is prohibited, and even under Juvenile Justice, Care and Protection of Children Act 2015, it is prohibited. So children cannot be punished by teachers, okay, and then that cannot be authority, and that authority cannot be used as a defense, okay. So if children's assaulted or hit, then tortuous action will lie, obviously, apart from the criminal liabilities. Nor can even parents beat up their children. I mean, there is no clarity of the law with respect to the with respect to that. There are parents, okay. Lots of other factors also do play a part. But then, if you look at the law generally, it's generally prohibited. So if a father beats up a child, the child can even take the father to the court and seek damages, okay. So I hope this is clear, okay. So this is no longer a defense. I'm just making it clear that parental authority or authority of that sort is no longer a defense, okay. Is that clear?
Yes, sir.
Okay.
Yes, sir.
So the next one now is exercise of common rights. So what are common rights? Common rights are essentially rights which are available to you, okay, under the under the laws, okay. So certain laws guarantee certain rights to you, okay. If you do your job under the authority of the law, okay, the rights are creatures. The rights that you are exercising are creatures of the law. Then even if the other party suffers some kind of injury because of that, that's a sufficient defense. Now, this is very clear to you already because we had already discussed, okay. The defense is of that of damnum sine injuria, someone who suffers damage but without any legal injury, okay. So remember, we discussed the example of you opening a shop to someone who already had opened their shop, but because you have a right to open your shop, even though it hurt the the other person in terms of profitability of the business, nonetheless you have done your act within your rights. So and that's a defense, okay. So what you are doing, if it is a matter of right, okay, whether under statute or under other laws, okay, then that is sufficient defense. So this is something that need not even be discussed to great extent, okay. So I hope this is clear then.
Yes, sir.
Okay, if the act that harms someone, okay, is not illegal, okay, it is legal, it is an excess, you have a right to do that, okay, you have a liberty to do that, okay, under the law, then even if it causes harms to other, it's a defense. So remember, we discussed all those cases in which people would dig up their ground, and that will affect the water flowing under the ground, and no causes of action lie because you were within your rights to do that. So that's the case here. That could be a defense, okay.
Sir, I wanted to ask something regarding this.
Yes, tell me.
It is all, sir, it comes under this ambit also and ambit of the assignment also. Sir, can we use this, can we mention this defense as showing how torts are disconnected to morality? Because like morals talk about not hurting everyone, and the basic purpose of morals is upholding social order. So if I say that torts are disconnected to morals, because it says that if I exercise my common rights, and if it hurts someone in that while exercising those, I am not liable under torts while my action might be morally wrong. So, sir, I hope that point won't be wrong.
Yeah, it won't be wrong in this instance, okay. But my point here is this, that, tort law of tort does not have to uphold all cases of morality. No, it does not have to uphold all arguments of morality. Law cannot possibly uphold all possible, points of morality, because even on moral questions, people disagree, okay. Some might say on this question itself that you were raising, from one perspective they will say that, okay, yeah, why is it immoral? Okay, how the hell is this a case of immorality? The other side would say that, well, yeah, clearly it's a case of immorality. He should have thought of his neighbors, okay, how his actions going to affect his or her neighbors. Okay, he did not think of it. So yes, it's not necessary that in a case of tort, every argument of morality will be upheld. But then the essential idea is that yes, in law of tort, many decisions are arrived at based on questions of morality. Do you understand?
Yes, sir. Sir, like I got your point. Like, law cannot uphold every moral because law is more codified. But like in the assignment, we have to take a polarized stand. It does or it does not.
Yeah.
So if I want to go with it does not, and if I want to give this example and then Gloucestershire, the grammar school case. So if I do that,
you can do that. No problem. I'm not saying that you cannot. Okay, but I'm just giving you my side of the story. That it's
okay.
Got the idea. You can say that, but I'm just telling you my side of the story. If there was one sure answer, then I wouldn't even ask you to write this project. I'm just telling you my point of view, okay? Because morality is a much complicated issue than this, okay? And it is essentially for this reason, later on in jurisprudence, you will see legal positivists say that law should be kept separate from morality, okay? Whether something is a law or not should not be decided based on questions of morality. It should be essentially based on whether the law has come from proper source or not, or many other definitions are there. We'll look at that later on. But I was just giving you the other side of the story. Okay, so you can write like that. Okay, so it's very early stage. So I wouldn't expect you guys to perfectly write it. Whatever your views are, if you put your arguments forward, I would just appreciate that. So yes, here, okay, sir, but teachers have quasi-parental. No, teachers can't hit. Okay, the law, it used to be the case. We followed the British model. Okay, earlier in England, the teachers, okay, had authority. So they had, quasi-parental authority. But in today's time, so you have all these international treaties and conventions. Okay, so you have Child Rights Convention. Okay, so clearly says that children are not to be, given corporeal punishment. They are not to be hit. Okay. Because what value do we teach our children if we tell them, okay, when we hit them, when we beat them up, we tell them that, well, the way to convince the other side is to beat them up, to rough them up. Okay, so we don't believe in all those ideas. So teachers in no situation will be justified to hit the students. Okay, if the student is being unruly, if he is doing something that is illegal, then you have legal recourse. You can also call their parents. Okay, you have the legal recourse, but you do not have the authority to beat them up. But that does not mean that you cannot prevent yourself from being hit. Okay, you always have the right to defend yourself. That's different. But you cannot discipline that child and using physical assault. That you cannot do. Even though teachers, so teachers see in today's time, the idea is that I'm teaching you, I'm getting paid. It's not any different relation. Obviously it's not just something I'm selling you. Definitely not. But then the fact that I'm teaching you does not give me authority to beat you up. As simple as that. It is prohibited by the law. So teachers, okay, even though they used to be considered as having quasi-parental authority, because most of your child life you spend with them in school. So they are to teach you the right value, and the right value is not to let you believe that violence is the way. They should not teach you the wrong teachings. That violence should be used to convince the other side. That's not acceptable. So is that okay, Sanskriti? So if you come across, so for example, okay, I will not give you real examples. Yes, I will not give you real examples, but yeah, let me tell you this. I have seen teachers doing this and I told them, do not do this. But I hear they nonetheless do it. But it is illegal, it is prohibited under the law. I told you, Right to Education Act, okay, prohibits, and Juvenile Justice Act 2015 also prohibits it. So yes, then I'll proceed. The next important defense is leave or license. Okay, essentially the maxim volenti non fit injuria. I think your English teacher is teaching you certain maxims. Huh? I might have to help her with this. Okay, so one maxim. Okay, before if at all I come and teach you all that later on. One maxim is this, that volenti non fit injuria. You will never forget this if you learn it now. So the idea is essentially this, that if you have voluntarily taken risk, okay, later on you cannot complain if you get hurt. Okay, so if you are the one who chose to be hurt, okay, who took the risk to be hurt, later on you cannot complain that, well, I am hurt. Okay, so it's a kind of consent that you have given. Okay, consent to be hurt, but consent to what kind of hurt? Okay, not every hurt is justified, so we will look into that. Okay, so so that's essentially what it means. Okay, that like if you choose to be hurt, okay, what, how shall I say? Okay, if you voluntarily suffer harm, okay, and then that would otherwise constitute a legal injury, but because you voluntarily chose to be harmed, okay, that is a defense for the other side. Okay, so in the famous case of Smith versus Baker and Sons, I'll just type it here. We'll discuss this. This is going to take some time. Just a second. So you see the case, okay, in Smith versus Baker and Sons, 1891, okay, it said the maxim was, defined like this, okay, that this maxim, okay, is founded on good sense, okay, and justice. It says one who has invited or assented to an act being done, towards him, cannot, when he suffers from it, complain of it as a wrong. Okay, so if you have assented to an act being done to you, that okay, you can do this to me, and then you suffer as a consequence, you cannot later on complain it as a case of wrong. Okay, so it essentially applies to intentional wrongs, okay, things which are done intentionally, which will otherwise be considered as tortuous, but because of volenti non fit injuria is not considered as tortuous. Okay, so we'll discuss some cases with respect to this. So the first case is Ilott versus Wilkes. Okay, I'll just write this here. 1820 case. So yes.
So we aren't required to discuss the facts and all of the Smith versus Baker and Sons?
No, just this thing will do. I'll give you guys some more important cases that will explain what it is. Okay, these are more popular. Yes.
Volenti non fit injuria was established by that case.
No, it's a maxim which exists. So it has been decided in many cases. We need not say that it was. So you have even older cases. So I'm giving you older cases. So that means the maxim existed even before. So I gave you the quote so that you understand what it means. Okay. So it was defined here like this, that one who has invited or assented to an act being done towards him cannot, when he suffers it, complain of it as a wrong. So this is the definition, you may say, of the maxim called volenti non fit injuria. Okay, so let's take an older case by the name Ilott versus Wilkes. Okay, so what had happened was that a trespasser, so you know what is a trespasser? A trespasser is a person who trespasses into another's property without their permission, without seeking their permission, without their consent. Okay. So, for example, I have a property, someone enters it without my permission, okay, is a trespasser to my property. So, a trespasser who had the knowledge, keep this in mind, having knowledge that there are spring guns, okay. So, spring guns are some, guns that, function based on spring mechanism, okay. In a wood, okay, jungle that belonged to the, defendant, okay. although he may be ignorant of the particular spot, so he didn't know where exactly those spring guns were located, okay, cannot maintain an action for an injury received in consequence of his accidentally treading on the latent wire communicating with the gun and thereby letting it off. So what had happened, as you can see in this particular case, okay, so the plaintiff here, who was a trespasser, entered into defendant's woods, okay, he knew that there were spring guns installed there, okay, but nonetheless chose to enter. He did not know where exactly the guns were placed, but there were, wires, okay, if you trip on that, okay, if you tread on that, then it will basically activate those guns. So he tread upon one such wires, okay, that activated the gun, and he was hurt as a consequence, okay. So when the matter was taken to the court, it was held that, well, the defendant had the defense of Volenti non-fit injuria. You put yourself in the way of danger, okay. Now you cannot say that I'm liable. I gave you reasonable warning, okay. So, but then you have to give the other person, reasonable warning. So you cannot just, for example, trespasser might enter your, your land. So it's highly likely that people will do that. But that does not mean that you can just put people in dangerous way. Okay, so for example, you might have seen people who electrify their fences. Okay, they put, notice boards that says, this fence is electrified. Okay, or they put signs, okay, that show that, okay, someone getting electrocuted and all that, to tell the prospective, okay, trespasser that, okay, you enter at your own risk, okay. So Volenti non-fit injuria is like that, okay. You voluntarily take the risk, and then you cannot say that, well, yeah, I have been, harmed. So is this clear?
Excuse me, sir.
Yes, tell me.
Sir, you have said that we have to clear the warning when we use this type of spring gun or electricity.
Yeah.
Sir, then what in the case of a person who is blind or illiterate or a small boy?
Yeah, so see the thing is that, law expects you to take all these things into consideration. So for example, if you have an open plot of land, okay, and you have some fancy berries growing there, some bright colored, red, yellow, whatever, that might, that might invite some, for example, little child, their curiosity, they might go there and pluck it and eat. Suppose those, berries are highly poisonous. So in such case, you cannot say that it was a case of Volenti non-fit injuria. You have to take reasonable precautions, okay? So maybe you should fence it. If it is that dangerous, you should fence it. So that's there, okay? So it's decided in each case by the court, but this is, if such a danger is in your property, and if there is a possibility that someone will come there and get hurt, then you have to take all those care. But then law does not expect you to take every possible care, okay? Someone who some crazy person enters your land, okay, and then gets hurt, I mean, that will not mean that you were to take all those extraordinary precautions to avert such incident from happening. But then law expects you to give, take reasonable precautions. So for example, if you're, planting poisonous berries, you might as well fence it, okay? Or if there are like, trenches that you have, dug adjacent to land, you at least, give warning to people that, well, there's a trench here. You cannot, for example, dig a trench and then cover it expecting people to come and fall in it. Okay, people can enter the property. So in such case, if you do, you have to give warnings to the people. That's essentially what the idea is. Now that you have given reasonable warning to the people, if people nonetheless choose to, be careless, then obviously, then you have the defense of Volenti non-fit injuria. So is that okay?
Yes, sir.
Okay. So yes.
I want to ask something.
Yes. Tell me.
Sir, for example, if in a zoological park there is a lion like enclosure, and it is all like very fenced and everything, and the visitors are seeing the lion in the cage, and so if the lion approaches them and tries to break the fence of the enclosure, and in case it breaks and he might eat one or two visitors, so will the zoological park authorities be liable?
Yeah, obviously, if the lion is able to come out, then obviously you were negligent in taking reasonable precaution to ensure that the lion stays caged. You have to do it. Because you are allowing people, letting people in, okay? People are not trespassing. You are letting people in, okay? And then the mechanism that you have put in there to ensure that the lions don't, get out of, those enclosures were not sufficient enough, okay? So the res ipsa loquitur, okay? Things speak for itself, okay? The fact that lions have gotten out of their cage and then hurt or, killed people itself says that, okay, you did not take reasonable precaution. Got the idea?
Yes, it is. Thank you.
Now, if people, so for example, you keep hearing, cases like, okay, stupid people. In Guwahati Zoo itself, it had happened. Stupid fellow, I should not say stupid, but yeah, he is stupid. As a teacher, I should not say all this, but yeah, I don't use all these words, okay? It's my mistake. Careless person, what he had done? He had put his, hand inside to take pictures of lion, okay? So there was a perimeter wall. It says, do not enter. That person jumps that perimeter wall, goes next to the cage, puts his hand inside to take a picture. There was another lion sitting underneath that this guy did not notice, who comes and, takes off, chops off his hand, and the guy dies later on. So you cannot in this situation attribute liability, because all, precautions were taken, all warnings were given, but you nonetheless chose to be careless, okay? So, yeah, Volenti non-fit injury. Yes.
Excuse me, sir.
Yes.
Sir, if consent is not free in this case, in this defense, then...
Oh, obviously we're coming to that. Very good question. Okay, the consent has to be free. That you are not coerced into giving your consent, okay? That cannot be the case. That cannot be a situation of Volenti non-fit injuria. The choice here, the consent here has to be free, voluntary. That's what it says, Volenti non-fit injuria. But if it is not voluntary, then obviously the defense does not apply. We'll come to that, okay? Vishwajit?
Yes.
Excellent question. Good, very good. So we'll look into all that. Don't worry. Let's take one more case today, and then we'll proceed with it in the next day. I'll record the lecture and upload. Don't worry. So another important case, okay, by the name Bird versus Holbrook. Just a second, I will give this to you. The name here. A similar situation, okay, just like the previous one, okay. So a person, okay, the plaintiff here was chasing a stray fowl, okay. It entered the defendant's, property. The defendant had installed spring gun, okay, just like the previous case, okay, but the defendant did not put any notice that there were spring guns, okay, installed, okay. As a result, the plaintiff got hurt, but in this particular case, it was held that the defendant was liable, okay, because it's not a case of Volenti non-fit injuria, because the defendant had not put notice, okay. So this is a different case, unlike the previous one. So you see, you can protect your property, you can take reasonable, precautions to protect your property, but then if you introduce dangers, okay, then you have to forewarn prospective trespassers, because trespassers, okay, they do not sign up for such dangers, okay. Some could be voluntary, other could be involuntary trespassers, okay. So you have to take those, things into consideration and put people into notice that yes, dangers are here. So enter at your own risk. So you see, if there's a dog in a house, people put up this notice that says, okay, vicious dog, enter at your own risk, etc., etc. Okay, that's very important. Okay, otherwise, anyone harmed would mean that there will be a case of tortuous case, and your defense of Volenti non-fit injuria will not apply. A very important example for this would be, for example, games and sports, okay? So there are lots of dangers involved. So think of boxing, okay? Let it be between, Mike Tyson and Holly Faith, if you remember those fights, okay? So when two players, okay, sign up for such, boxing matches, okay? They are to play by the rules, okay? Boxing, they have certain rules that you are not to hit below the belt, etc., etc. Okay, obviously you are not to bite off your opponent's ears. Okay, so but then you hit one another, na? So if one boxer hits the other, Mike Tyson knocked off so many people, na? Knocked out so many people. Okay? Okay, now those who were knocked out, okay, they suffer, some harm, physical injury. And had it been not in a game, they could have taken Tyson to the court. But because they have, by virtue of this, this agreement between them, they have put themselves in the way of danger. Okay, they have chosen to be harmed. Okay, so you have voluntarily chosen to be harmed. Okay. It's not even that, okay, essentially what is this, that there is no right here for you because you have given up the right, okay. So now that you have put yourself in the way of harm, okay, you have consented to being harmed, okay, you can't later on complain that, okay, yeah, I was hit. And then there'll be no such game. So, but then that does not mean that Mike Tyson can bite your ear off, okay. So if Mike Tyson, bit Holyfield's ears off, that's definitely tortuous. Okay, for that he can definitely be taken to court and then sued and compensate. So can be asked to compensate. So I hope you understood. Got the idea?
Yes, sir.
So you consent to only what is necessary here. Okay, the game requires that one hits the other in a certain way, in certain regions of body. So you have to abide by that, and if you don't, then obviously. So we'll end it there for today, okay? And then we'll carry on with the rest in the next class. I'll record and upload some lectures in between because